Good day, ladies and gentlemen. This is Joy Stephen once again from the Polinsys Studios. This video is taken for the Student Herald, and the topic: new rules, citizenship rules in Canada. In this video, I will give you the old regulations and the new regulations. The old regulations will work until the time the new regulations take over, which was released recently. There are several points covered in this video, and therefore I've tried to be a little fast. If you have any doubts, please also check back on the transcripts which I have provided in a chart format, which is very easily understandable. Now let's talk about the old residency rules for citizenship. You must be living in Canada for 3 out of the 4 years, that is 1,095 days. There was no requirement that you be physically present, and you can also count the time you spent as a non-permanent resident towards the residence for citizenship. Example: a student may count the study time he spent on a study permit towards citizenship. You do not need to prove that you intend to reside in Canada. And these are the old regulations. The new residency regulations will require you to be living in Canada for 4 years, that is 1,460 days out of the 6 years for citizenship eligibility. You must be actually physically present in Canada for at least 183 days per year in the 4 years out of 6 years. And also, you cannot really count the time spent as a non-permanent resident, non-PR, towards residence for citizenship. And you must prove that you actually intend to reside in Canada. Now let's go back to the old citizenship rules. Citizenship applicants are aged between 18 to 54. They must meet language requirements and pass the knowledge test. Upper age limit was 54, currently established by policy, not by legislation. They may use an interpreter to meet the language requirement at the citizenship interview. The new regulations: citizenship applicants aged 14 to 64 must meet language requirements and pass the citizenship test. They must meet knowledge required in English or French without interpreter. Now let's go back to the old. Lost Canadians are people who were not granted citizenship due to changes in the law. If you are a lost Canadian, you may or may not have had your citizenship restored in 2009. The new regulations: if you are a lost Canadian born before 1947, you and your first generation children born abroad will be granted Canadian citizenship. The old regulation: if you are an immigration consultant, you are not required to be registered or regulated in order to represent people in citizenship matters. There were hardly any penalties to deter you from fraud and tools to ensure the integrity of the programs. Fines and penalties for fraud was a maximum of only $1,000 or 1 year in prison. The new regulations: if you are an immigration consultant, the amended act defines who is an authorized representative, develops regulations to designate a regulatory body, which is ICCRC, can refuse your application for fraud, set fines and penalties for fraud at a maximum of $100,000 and or 5 years in prison. Now, the old regulation: the Governor in Council, GIC, makes the final decision to grant citizenship on a discretionary basis. The new law: the Citizenship and Immigration Canada, CIC, minister can decide to grant citizenship on a discretionary basis. Now going back to the old law, the Act does not define what is a complete citizenship application. The new law: the new Act defines what is a complete citizenship application and also what evidence you have to provide when applying. The old law: there is a multi-stage 3-step decision-making process to decide on whether to accept your citizenship application. The new law: there is a single-step decision-making process to decide on whether to accept your citizenship application. Now, the old law: you are not required to file Canadian income taxes to be eligible for citizenship. And the new law, you are required to file Canadian income taxes to be eligible for citizenship. The old law, if you have domestic criminal charges and convictions, you cannot get a Canadian citizenship. You cannot. The new law, if you have a domestic and or a foreign criminal charge or convictions, you cannot get a Canadian citizenship. Pretty much the same. Now going back to the old law, the Governor and Council, this GIC, makes a final decision about whether to revoke your citizenship. The new law, the Citizenship and Immigration Canada CIC Minister can revoke your citizenship if it is a routine case. The Federal Government of Canada decides whether to revoke your citizenship if it is a complex case, example, war crimes, crimes against humanity, security, other human or international rights violation, and organized criminality. Now, the old law, you cannot have your citizenship revoked for acts against Canadian national interests or Canada's national interest. The new law, your citizenship can be revoked or denied if you are a dual citizenship or a permanent resident of Canada and a member of an armed force or an organized armed group engaged in armed conflict with Canada and or convicted of terrorism, high treason, treason or spying offences depending on the sentence received. The old law, if you are a member of the Canadian Armed Forces, there is no fast-track citizenship process for you to apply for. Under the new law, if you are a permanent resident, serving with or on exchange with the Canadian Armed Forces, you can apply for citizenship under a fast-track process. If you were a member of the Canadian Armed Forces, CAF, or a foreign military member who is or was attached or seconded to the CAF, you can apply for citizenship under a fast-track citizenship process. And this is the changes in the regulation. I hope this video has given you some insight to the new citizenship regulations. From all of us here at the Podensis Studios and to all of you subscribers for the Student Herald, au revoir. Thank you.